Hello, this is Chris Berry with Castle Wealth Group, and today we're going to talk about the differences between guardianships and power of attorney.
Christopher Berry is a leading estate attorney and advisor in the area of retirement and legacy planning. He has been featured in publications such as Forbes, Kiplinger's, Crane's Detroit, and more. He's the host of the weekly radio show and podcast, The Chris Berry Show. He's a national thought leader as it relates to retirement and legacy planning, and has authored the Amazon best-selling book, The Caregiver's Legal Guide.
So as an elder law attorney, I've seen a lot of families reach out to our office asking to say, hey, I need a guardianship for my mom, my dad, my loved one, my spouse. When in reality, they probably want a power of attorney. There's two types of powers of attorney. There's a financial power of attorney and a medical power of attorney. Now, why would a family call us asking for a guardianship? Because they think they need to take control over a loved one's either finances or care. And they think that the only way to go about it is to go to the probate court. And so we call this living probate, where you petition the court to appoint a guardian, someone to make financial decisions and then medical decisions as well for that person they're caring for. But understand, there's an alternative. You don't have to go to the courts. The courts have a set of rules, and you can go to the court to apply that set of rules, or you can create your own rule book. And that's really what a financial and medical power of attorney is all about. It's all about creating your own rule book. This is good to set up ahead of time before there is any questions of incapacity. But if you do have a loved one who has dementia or Alzheimer's or is starting to just decline, understand that even if they have a diagnosis, they may still be able to execute their own financial and medical power of attorney, appointing you to be able to make these decisions for that person you're caring for. Now, why would you want a financial and medical power of attorney instead of a guardianship? Because understand, when you go the guardianship route, now you're bringing the courts, the state of Michigan, into your affairs. And now it's not going to be you making decisions for that person that you're caring for. Now it's going to be the state of Michigan, the judge, and the courts. Now you might be able to execute on those decisions, but if you wanted to sell a house or something like that, you're going to have to get the judge's approval. And then you're going to have to do an annual accounting to the court about how you spent that money, which could be a good thing. But most of my families, they want to keep the courts out of their affairs. So instead of going that guardianship route, instead, probably your first opportunity or first route would be to go to that financial and medical power of attorney. Because also understand, when you go the guardianship route, now the court's going to appoint a guardian ad litem who's going to come out and interview the person who you're caring for, and the judge may decide that you're not the right person to care for that person. And then also, when you go the court route, not only is the courts in the state of Michigan in your affairs, but now there's additional costs associated with that as well. So ideally, the first step would be to go the financial and medical power of attorney route. The guardianship route is really a matter of last resort. The only time that we recommend going the guardianship route typically is if there's infighting amongst the family deciding how things should be taken care of. So this has been Chris Berry with Castle Wealth Group. Hopefully now you understand the difference between guardianships versus powers of attorney. Thank you.
Castle Wealth Group has clients across the nation and helps families plan, protect, and preserve what is important by creating a retirement and legacy blueprint.